Thank you, Judge Tolliver and members of council and everybody in the room this morning. For the record, my name is Vincent Robertson. I'm one of the assistant county attorneys here in Sussex County, and I am defending the Planning and Zoning Commission's denial of this application. What I wanted to do, sort of before I get into the heart of my presentation, is run through a few things that Mr. Townsend stated that I think need to be addressed right up front. He stated a couple of times that this is the first denial of a subdivision plan by Sussex County, and that it's somehow unique, or I don't know, this just never happened before. We get accused of that an awful lot, of approving everything, but that's not actually true. I'm not prepared to cite specific subdivisions that have been denied by the county in the course of even my 20-some years here with Sussex County, but there have been some. But I'll just point out, that's not even part of the record. I don't think that's something to consider. It wasn't on the record below. It's on the transcripts, whether we've approved or denied anything in the past. But I will state, since it was brought up, that there have been ones that have denied. Not often, admittedly, but they have been denied. There was a comment that somehow this one got denied because it was not a cluster subdivision and that the Planning and Zoning Commission prefers cluster subdivisions. I would suggest that's also an irrelevant consideration. Nowhere in the Commission's findings was there a reference to the fact that we would prefer this to be a cluster subdivision. So I don't think you should consider that. And there was the comment about density being increased if somehow this got denied and it got redesigned and came forward by another developer. That's simply a misstatement. The density, it's AR1, it's 2 units an acre. That's what you get. You can get whatever amount of lots you want as long as it doesn't exceed 2 units an acre. And then I'm going to get to this in some more later on, but really the heart of this, and I would say the showstopper for it, is that the septics. There was a comment about, and it's throughout all the presentations, it was the subject of a lot of the Commission's deliberations, that feasibility study. And the original soils tests were done in 2006, as you well know, which is 15 years ago. They were reviewed by DENREC in 2015. Mr. Townsend talked about that it was for 25 lots, and therefore it's the same. It was not these 25 lots. We don't know what 25 lots it reviewed because we never saw the plan that DENREC reviewed in 2015 that accompanied that feasibility study and that DENREC review back in 2015. So the Commission had no way of knowing whether DENREC signed off on a soil evaluation for the same lots that were in front of the Planning and Zoning Commission this past summer. The Commission kept asking for that information through DENREC, and DENREC came back and said, well, that's true. The soils don't change. Agreed. The subdivision changed. And we don't know whether that subdivision changed a little bit or materially, because we never saw that subdivision that was associated with what DENREC reviewed back in 2015. And I will say, too, everybody seems to say that the soils don't change. And there's actually, and that's true, but in the emails from DENREC that came to Sussex County, they actually do state that if the situation on those soils changes, if they're compacted, if they're regraded, if something happens in those 15 years, then that could void out that feasibility study or DENREC review that occurred 6 years ago. Again, we don't have anything in the record to confirm whether the actual on-site conditions changed from 2006 to the present, and we didn't have anything in the record to show that that site plan, whatever it was in 2006, is the same as what was reviewed by the Commission in this past summer. Mr. Townsend talked about the Ashburn case. I would point out that that's a Kent County case. It dealt with a Kent County ordinance, and as he stated, that Kent County ordinance, and the whole thing with Ashburn, it was because it deferred reasons for decision out to either plus, as Mr. Townsend stated, concerns about schools, concerns about level 4, concerns from the Department of Agriculture, and again, concerns about plus. Because I agree with him that you have to have code-based criteria. You can't have these criteria, ad hoc criteria is what these cases talk about. Other people's opinions, basically, that come in and facilitate a decision of Sussex County. We don't have that here. We actually have code-based criteria. We have those 17 items in our R code, not what does PLUS think. It's what is in our code in 99-9C. I appreciate that Mr. Townsend stated that the Planning and Zoning Commission is not a rubber stamp. It has discretion. That's in, I think it is in Ashburn. It might have been one of the cases quoted by Ashburn. But actually, if you look at 99-9, it makes it clear that the, and I'm quote 99-9A, the Commission shall either tentatively approve or disapprove or conditionally approve the plat subject to specific changes or modifications. So denial is one of the options that is available to Sussex County's Planning and Zoning Commission with regard to a subdivision application. Really what, as I mentioned before with the septics, this case boils down to an applicant having to make a record that the Commission can adequately make a decision upon and consider. The Commission can't be the one to make a record or design the subdivision. You know, it seems as though here what we're being asked to do is say, okay, we're going to throw a bunch of information at you, some of it outdated, and then with some questions on a site plan, Planning and Zoning Commission, you take that and you try to figure out how to design a subdivision. That's not the role of the Sussex County Planning and Zoning Commission. There was also a question about basically saying that that 99-9C only requires or only permits conditions on an approval. To me, that's backwards. It's essentially would be saying, well, you have to approve it, then you have to backfill all those things that we don't know about by placing conditions on the subdivision. No, what you have to do is satisfy those 17 items in 99-9C, and then if they're satisfied in accordance with 99-9A, then you can approve it. And the septics, as I said, that's the real, essential concern on there. On the denial. And those show up throughout the code. 99-97 requires septic feasibility, along with 99-24 requires septic feasibility. There's an important reason for that. And that historically is something we always ask for at the Commission, whether it's a 500-lot subdivision or whether it's a 2-lot subdivision. It can't get approved until there's septic feasibility. We don't want to approve a lot that can never be built upon, either because it doesn't have central sewer or because it doesn't have the capability of an on-site septic system, whether it's a mound system, whether it's a standard septic system, whatever. But we have to know that there's septic feasibility. You have to know that up front. You can deny or you can decide where you're going to place the septic system later on down the line at final site plan or at construction, but you have to know that lot is capable of being constructed because it has septic feasibility. Again, we did not know that here because we had soil evaluations from 2015. We don't know if those soils changed. We had DENREC's review of 2006, or excuse me, we had the soil evaluation of 2006. We had DENREC's review of 2015. And at that time, it was for a plan that the Commission never saw. So we don't know if the lots that were presented to the Commission this past summer actually could be served by an on-site septic system. With regard to the Council's rule today, as Mr. Townsend stated, and as you all well know, what you need to look at was the Commission's review the result of an orderly and logical review and a proper interpretation of the chapter. As Judge Tolliver mentioned, there were 4 different considerations by the Commission. There was the public hearing in June, old business in July, and that included a thorough explanation and a question and answer session with staff, and the record was added to with regard to DENREC and DelDOT. There was again old business discussions in September with further discussions with staff, and additional information from DENREC was discussed, and then the old business vote occurred in October. There was a lot of deliberation. I'm not going to go through the whole record because you have the transcripts, so we believe that was satisfied. There was also, as we're going to go through, substantial evidence and a proper application of Chapter 99 by the Commission as part of its decision. Keep in mind that this was somewhat of a unique subdivision. It was different than a lot that the council or that the commission sees. It was 25 lots, but we don't often see one that's bounded on one side by Beaver Dam Creek or a water body, on the other by the Broadkill River, and containing approximately 28.7 acres of wetlands. And there was a question about whether it was 28.7 because at one point during the testimony there was a comment that it may actually be 65.9 acres of wetlands. So there was some concern about actually what the amount of the wetlands were on the site. But ultimately, as we know, the Commission denied the application because the applicant did not favorably address the requirements in 99-9C. And as we stated, the consideration shall include a consideration of those 17 items. And the Commission went through the ones that it believed the applicant failed to properly address during the public hearing and based upon the record. And I'm going to just run through those real quick because that's the heart of this whole thing. The first one was Section 99-9C1, which concerns an integration of the proposed subdivision into the existing terrain and the surrounding landscape. As mentioned, there was extensive wetlands and woodlands on the site, and all of the buffers are located within the woodlands on the individual lots. As I mentioned, it was unclear if there's 28.7 acres or 65.9 acres of wetlands. And there was testimony that everywhere you see woods, it has wetlands. That was at the transcript at page 7, lines 6 and 7. Then on top of that, the site plan noted that the tree line shown was for estimated lot clearing only. Actual lot clearing varies. And then there was also in the transcript a statement, unfortunately, if the best septic areas gets deeper into those woods, you want to clear those woods for those septics. So we have extensive wetlands, we have woodlands that contain the wetlands. We're not sure where the wetlands are in relation to those woods. We're not sure what the total amount of the wetlands are. And then we have the statement that the tree line may change, and then we have the statement that the septics may dictate those woods being removed. There's simply, from the record, no protection of the wetlands, the buffers, or the woodlands. Again, they're all within the lots and all admittedly subject to removal by the lot owners. So that was the basis for the finding that Section 99-9C1 was not satisfied. The next one was 99-9C2, which addressed the minimal use of wetlands and floodplains. Again, we're not talking about a small amount. It's either 28.7 acres or 65.9 acres. I'm not going to reiterate the same comments as 99-9C1, but those apply all equally to 99-9C2 regarding the minimal use of wetlands and floodplains. 99-9C3 deals with the preservation of natural and historic features. The Commission found that the design of the subdivision is counter to the preservation of the natural areas since the lots are oriented to the perimeter of the site where the woodlands, wetlands, and waterways are located. There was some testimony that the design of it was because of the soils, that the bad soils, I guess, are in the middle, and that's where the lots are located. But again, we don't even know because we never saw the original plan that was in conjunction with that 2015 DENREC review of the soil evaluation. The Commission next found that 99-9C4 was not satisfied, and that's the preservation of open space and scenic views. In this case, they found that the design does not preserve scenic views because the primary scenic view is the man-made lagoon and its view of the Broadkill River beyond it. That lagoon was entirely within one of the lots, and as was stated during the record, the intent is to build a nice home on that property and maximize the view of that. And also, while there would be a dock, there was testimony in the record that the dock will be private on that lot. So, we talked about the preservation of open space, but the scenic views were not preserved because actually they were going to be utilized by one single lot within this subdivision. So the Commission found that 99-9C4 was not satisfied. Commission also found that 99-9C5 wasn't satisfied, which is the minimization of tree vegetation and soil removal and grade changes. I'm not going to restate those reasons, but again, all 38 acres of the existing forest was located within the individual lots. There was going to be extensive tree removal based on the statements in the record regarding the septics and the statement that the tree line is showed for estimated lot clearing. Actual lot clearing varies. There was no justification that the tree removal would be minimized. Then the big one was the eighth reason, which was the Commission's finding that Section 99-9C8 was not satisfied. Again, the applicant was proposing 25 individual septic systems. The septic systems based upon that 15-year-old soil evaluation and the 2015 DENREC review. I just want to point out a few details on that. In the statement, or in the transcript, there was a statement that the soils are marginal. Like the other plan had before, mound systems. There are some bad areas on the site. Well, the Commission didn't know where those bad areas were because, in relation to the current lots that were before it this summer, because we didn't have the bad areas or the mound systems to compare it to from that 2006 plan. That 2015 DENREC review also referred to specific lots from that prior subdivision, and we had no way of knowing as the Commission where those lots were that were problematic in relation to this subdivision. It actually referred to lots 2, 4, 12, and 13 being bad soils, and lot 3 being totally unbuildable. Taking that information from 2015 and trying to guess where those lots would be and whether there was septic feasibility on this plan that was being reviewed by the Commission is not the Commission's job. And frankly, this would have been easy to fix. If they had just run this back through DENREC with this plan, we wouldn't have been having this discussion. There's actually, there's two things that could have happened here. One is you get an updated DENREC review of the soils versus this plan. You have that in the record. We're good to go. Or two, you connect to central sewer, and then you're good to go. Either way. We know the second one they didn't do because in the record it stated the developer has been contacted several times about expanding the sewer, but that doesn't make sense for what he's proposing. And I think what this comes down to is when you see transcript page 11 at 17 to 19, the statement was, we've tried to maximize the number of lots that still financially work for the property. So there was a decision made, a conscious one, not to get an updated DENREC review of this plan so the Commission would know what it's looking at with regard to the soils. Or there was a conscious financial decision not to connect to central sewer that would have eliminated this question altogether. Neither one of those things were done. That left a big question mark for the Commission, and the Commission felt like it didn't have adequate record to approve this subdivision based on the ability to have individual on-site septics on the lots that were before it this summer for consideration. The Commission actually asked for some follow-up information from DENREC, and there was a lot of back and forth, and the emails are in the record. And DENREC's sort of final response was that there is no expiration date associated with the soil feasibility study that was performed. However, DENREC cannot confirm that site conditions have not changed since that time in 2006 without submission of additional updated information. That additional updated information wasn't submitted. So again, based on DENREC's own information, setting aside that the plans have changed, we don't know that the soil site conditions the site conditions haven't changed since 2006, which is 15 years ago. So again, that was a gap in the record that the Commission took into consideration when it denied this application. The next item that the Commission considered was Section 99-9C11, which requires the consideration of safe vehicular movement within the site and to adjacent ways, and Section 99C15, which requires the consideration of the effect on area roadways. The Commission did take this into account. There was a lot of testimony in the record about it. There was some discourse between the applicant and the Commission about it. The opposition testimony all concerned this because this property is located on Round Pole Bridge Road, and it's very near a bunch of substantial curves and an old bridge on the property. There was information that was provided by DelDOT that you had to be an engineer to understand, but essentially said that that bridge was fine and that wouldn't impact anything. But the Commission was concerned, based upon the information in the record, about placing this subdivision with its entrance right on this place or this location on Round Pole Bridge Road with all these 90-degree turns and 45-degree turns. One of the things that, there was evidence that from neighbors, members of the public, that this is a heavily traveled road by farm equipment. The applicant stated that the road was 20 feet wide. We had testimony in the record, it was 20 feet wide, tar and chip. There was testimony in the record that actually it may have been 18 feet wide, but there was quite a bit of information presented that it's bad if cars need to pass each other. It's worse if agricultural equipment, which uses the road a lot, needs to pass. And it's even worse if the corn's high at that time of the year and you can't see around these curves and you've got a combine or something coming around a corner. It's just a bad place to put a subdivision. That was all information in the record. That was all information that was considered by the Commission in finding that 99-9C11 and 99-9C15 were not satisfied. So the Commission did go through a lot of deliberations and considered all the information in the record. Frankly, I think it really came to the conclusion that you can see that's at least implied in here, if not expressly stated, that there wasn't enough of a record to go on. Whether it's the soil feasibilities, whether it's a question about where those woodlands were, whether it's a question about whether those woodlands would be disturbed or not. How do we know that that buffer is not going to be disturbed when we have statements in the record that the woods are going to be removed, which includes the buffers, if we need to put septics in, on top of the fact that we already know that the soils out there are marginal for septics in the first place. There were just simply too many unanswered questions, and I think you'll see that as you review the Commission's unanimous motion to deny this application. There was an orderly and logical review of the record over 4 meetings. There was a proper review of the code. It, again, was based on considerations in our code, not based on some plus comments or whether we're in level 4 or not. It was based on our code in 99-9, which allows the Commission to deny a subdivision, which it has done before historically, and that decision was based on the record. And I'll sum it up this way too, and this came up in the last hearing as well. It's not the council's job to maybe find that it would have made a different decision based on the record. You just have to look at, was there substantial evidence to support the Commission's decision? And did the Commission itself, based on what it heard, conducted an orderly and logical review of the record? I think based on the thorough motion to deny this application, based on our Sussex County Code, based on the transcript references, the documentation that was in the record and everything else, that the Commission did put a lot of thought into this decision, did a lot of consideration of the record or the questions in the record, and came up with the appropriate decision to deny the application. So with that, I'll open myself up to any questions that you may have.
The applicant does have the opportunity to address the questions and concerns and reapply. Is that not right?
Yes. So they could reapply. Off the top of my head, I know in the zoning code, and I have to apologize, I don't know off the top of my head in the subdivision code, and I should know it. There is a waiting period, I know in the zoning code of a year, but I apologize, I can't recall if that's.
Do we give any accommodation for that type of thing to expedite?
That's probably a question for Mr. Moore, not for me. So, yeah.
I don't know if we have a policy to give accommodation for that type of thing or not, but nevertheless, they would have the opportunity to take the decision and address the unanswered questions and come back. I mean, there's nothing stopping them from doing that.
Yeah, that's true, yes. I mean, whether it's a septic, any of those items, yeah, anybody could come back in and, again, I don't know the timing issue that, but off the top of my head, but that is.
Yeah, I understand there's carrying costs and there's, financial concerns of the applicant, but it is still on the table.
Thank you.
Thank you. Any other questions? Thank you. And I don't need to reserve any time unless Mr. Townsend drops some bombshell on me in his 30 seconds he has left. Thank you.
Mr.